You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. Domain I introduces the structural backbone of the U.S. privacy landscape by linking the nation's legal system to the mechanisms that govern privacy regulation and enforcement. At its core, this domain emphasizes scope, what laws apply, who enforces them, and how organizations must respond. Unlike some jurisdictions that establish a single, comprehensive privacy statute, the United States operates within a fragmented framework where authority is divided among multiple branches of government and dispersed across federal and state regulators. This creates a complex but dynamic system in which privacy obligations emerge from constitutional principles, statutes, agency rules, judicial interpretations, and contractual commitments. For exam candidates, this means that success depends on both understanding the architecture of the system and recognizing how these legal sources interact to shape practical compliance. Domain I provides the vocabulary and structure for all subsequent domains. The three branches of government each play a distinct role in shaping privacy. The legislative branch creates statutes that establish sector-specific obligations, such as HIPAA in healthcare or GLBA in finance. The executive branch, through regulatory agencies, enforces and interprets these laws by issuing rules, guidance, and penalties. The judiciary evaluates both statutory and constitutional claims, setting precedent that influences interpretation across the country. For example, the Fourth Amendment's protection against unreasonable searches has been central to decisions about government surveillance. These branches do not act in isolation, but form a system of checks and balances that ensures no single entity controls privacy regulation. For learners, recognizing this interplay provides a framework for analyzing questions that describe a particular enforcement action or dispute, anchoring the answer in the correct branch's authority. The sources of privacy law can be categorized into constitutions, statutes, regulations, case law, and contracts. Constitutional law establishes broad principles, such as limits on government searches. Statutes are legislative enactments like COPPA or FERPA that define specific duties. Regulations translate those statutes into detailed operational rules, such as HIPAA's privacy and security rules. Case law arises when courts interpret these laws, often clarifying ambiguities or resolving conflicts. Contracts play an increasingly significant role in privacy, as companies bind themselves to obligations and agreements with consumers, vendors, or partners. Each source operates with different levels of authority, but all must be considered in practice. For exam preparation, knowing which source governs a particular scenario is essential, as the obligations and enforcement mechanisms vary depending on the type of law in play. Jurisdiction and scope determine whether a law applies to a given activity, person, or organization. Federal laws may have narrow scope, applying only to specific industries, while state laws like the CCPA have broader reach, but only within their geographic boundaries. Choice of law principles complicate matters further when transactions or data flows cross borders. Courts and regulators must determine which jurisdictions' rules apply, particularly in online commerce where state lines blur. For exam candidates, jurisdictional questions often test the ability to identify whether federal or state law controls, or whether a contractual provision shifts applicable law. Recognizing the boundaries of scope helps prevent overgeneralization, ensuring that each law is applied only within its intended domain, while still understanding how overlapping jurisdictions create layered obligations. Preemption doctrines are central to resolving conflicts between federal and state privacy laws. When federal law explicitly or implicitly overrides state law, state-level obligations may be nullified. For example, federal credit reporting law preempts certain inconsistent state provisions. However, where preemption does not apply, states often impose stricter standards, creating dual layers of compliance. Understanding preemption is essential for exam purposes, as many questions hinge on whether state laws survive alongside federal frameworks. This doctrine reflects the broader federalist structure of the U.S., where national authority and state innovation continually interact. Learners who grasp preemption can more effectively analyze scenarios involving conflicts, recognizing when federal supremacy prevails and when organizations must navigate parallel sets of requirements. The availability of private rights of action influences enforcement strategy significantly. Some statutes, such as the Fair Credit Reporting Act, empower individuals to sue directly for violations. Others, like HIPAA, restrict enforcement to regulators. Legal standing further complicates this, requiring plaintiffs to show concrete injury before courts will hear their claims. In privacy cases, demonstrating injury can be difficult, especially where harms are intangible, such as loss of control over data. For learners, these terms illustrate the difference between laws that rely on government enforcement and those that permit direct litigation. On the exam, recognizing whether individuals can sue under a given statute is critical, as it alters both the enforcement landscape and the strategic risks organizations face when handling personal information. Liability theories provide the legal basis for privacy enforcement. Contract liability arises when companies fail to meet obligations set in agreements, such as service-level promises about data protection. Tort liability may be based on negligence, where an organization's failure to protect data results in harm. Civil enforcement includes actions brought by regulators, often resulting in penalties or consent decrees. Each pathway has different remedies and thresholds. For exam candidates, the key terms are contract, tort, and civil enforcement, emphasizing that liability can arise from multiple directions simultaneously. This variety illustrates why privacy compliance must be comprehensive, addressing both legal mandates and promises made in contracts, since failure in either arena can create substantial exposure. Fiduciary duty in data stewardship is an emerging concept that frames privacy as a responsibility of trust. Just as financial advisors owe duties of loyalty and care to their clients, organizations handling personal data are increasingly expected to act in the best interests of individuals. While not universally codified, this concept appears in debates and some state-level proposals, reflecting a growing expectation that companies protect individuals proactively. For exam purposes, fiduciary duty terminology signals obligations that go beyond compliance checklists, emphasizing fairness and responsibility. This term also illustrates how privacy is evolving conceptually, borrowing from established legal doctrines to frame modern information relationships in terms of trust and stewardship. Unfair and deceptive acts and practices provide another critical enforcement pathway. Under Section 5 of the FTC Act, the Federal Trade Commission can pursue organizations that misrepresent privacy practices or fail to safeguard data adequately. Deception occurs when companies promise protections they do not deliver, while unfairness covers practices that cause substantial harm without offsetting benefits. Remedies often include fines, consent decrees, and ongoing oversight. For candidates, the UDAP framework is central, as it allows broad privacy enforcement even in the absence of sector-specific statutes. Understanding how UDAP principles apply to privacy ensures readiness to analyze scenarios where company practices fail, not because of explicit statutory violation but because of misleading or harmful conduct. Federal agencies each play unique roles in privacy. The Federal Trade Commission acts as the primary enforcer of consumer privacy standards. The Federal Communications Commission regulates telecommunications privacy, including rules around call records and customer proprietary network information. Other agencies, such as the Department of Health and Human Services, enforce health privacy through HIPAA, while banking regulators oversee financial institutions. The Department of Commerce has historically engaged in international data transfer frameworks, such as the Privacy Shield. For exam purposes, recognizing which agency governs which area is essential, as many questions test the ability to connect obligations to the appropriate regulator. This reflects the decentralized but specialized nature of U.S. privacy enforcement. State attorneys general add another enforcement layer, often leading cases under state consumer protection statutes. Insurance departments may regulate data practices in financial and health-related contexts, enforcing rules designed to prevent unfair discrimination. These state-level actors can act independently or coordinate with federal agencies, creating multi-front enforcement challenges for organizations. For exam candidates, understanding the role of state enforcers is essential because it reinforces the patchwork nature of privacy compliance. A practice lawful under federal law may still trigger state-level scrutiny, underscoring the importance of considering multiple enforcement vectors simultaneously. Self-regulatory models and industry codes of conduct represent voluntary frameworks designed to fill gaps or demonstrate accountability. Examples include advertising industry initiatives for behavioral targeting or sectoral codes adopted by professional associations. While not legally binding in the same way as statutes, they carry reputational weight and can be enforced contractually. For learners, the key terms are self-regulation and codes of conduct, which highlight how organizations use these models to anticipate regulation, build consumer trust, or negotiate lighter enforcement. On the exam, candidates should recognize that while self-regulation supplements legal compliance, it cannot replace mandatory obligations. This distinction is critical in understanding how governance frameworks evolve in practice. Global Privacy Enforcement Network cooperation illustrates how enforcement transcends national borders. Regulators across jurisdictions collaborate to investigate and address violations, particularly in cross-border data transfers or multinational operations. For learners, this demonstrates that privacy enforcement is not confined within U.S. boundaries but increasingly global in scope. Exam scenarios may test recognition of international cooperation as part of enforcement, emphasizing that privacy professionals must consider global implications even when focusing on U.S. frameworks. This term reinforces the idea that privacy is inherently international, requiring alignment of domestic enforcement with global practices. Self-regulatory enforcement mechanisms like trust marks and seal programs add another layer of compliance signaling. Organizations can display seals or certifications demonstrating adherence to recognized standards, often backed by audits or third-party validation. While voluntary, these programs provide accountability and can mitigate enforcement risks by showing proactive compliance. For candidates, recognizing these terms emphasizes that privacy governance includes both mandatory and optional mechanisms, each serving different purposes. Trust marks reassure consumers, while also demonstrating to regulators that organizations take obligations seriously. On the exam, these terms may appear in scenarios testing the difference between legally binding enforcement and reputational or contractual mechanisms of compliance. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Data inventory practices are the foundation of privacy management. An inventory catalogs what personal information an organization collects, where it is stored, and how it is used. Without this visibility, it is impossible to apply controls consistently or demonstrate compliance. For example, if an organization cannot identify which systems hold sensitive financial records, it cannot ensure those records are encrypted or properly disposed of. Inventories often expand into data maps that show flows between systems and vendors. For exam purposes, the key idea is that inventory precedes all other governance functions. It transforms privacy from an abstract concept into a concrete set of records, enabling organizations to apply rules, allocate responsibilities, and respond efficiently to requests from consumers or regulators. Without a robust inventory, every other privacy control risks being incomplete or misapplied. Data classification schemes build on inventory by assigning sensitivity levels to personal information. Not all data carries equal risk. A public directory may warrant minimal safeguards, while health or financial records require stringent protection. Classification systems typically assign categories, such as public, internal, confidential, or restricted, mapped to appropriate safeguards. For learners, the key term is alignment, meaning controls must match sensitivity. This ensures proportionality. Encryption is applied where justified. Retention schedules are stricter for high-risk categories, and access controls are layered accordingly. Exam questions may test recognition of which safeguards align with which classification. In practice, classification systems create a scalable way to prioritize resources, ensuring organizations focus their strongest protections on the information that matters most. Data flow mapping extends inventory and classification by showing how information moves within and outside an organization. It identifies points where data enters, travels between systems, and exits through vendors or cross-border transfers. Mapping is critical for vendor management, contract drafting, and compliance with international transfer rules. For example, a company may discover that customer data collected in the U.S. is stored on servers abroad, triggering obligations under foreign frameworks. For exam candidates, mapping is a foundational concept that connects technical processes with legal compliance. It makes abstract obligations, such as providing notice or controlling sharing, tangible by showing exactly where data resides and how it moves. In practice, flow maps are invaluable for incident response, enabling rapid assessment of which systems and partners may be affected by a breach. Privacy program development represents the organizational side of compliance. A comprehensive program includes governance structures, written policies, documented procedures, and designated privacy officers. It establishes how an organization translates legal requirements into day-to-day practices. For learners, the operating model is the critical term, referring to how roles, responsibilities, and processes are structured. Exam scenarios may test whether a described program element reflects an adequate operating model. For example, a program that lacks documented training may fail accountability standards. Building a program is not a one-time project, but an ongoing effort, adapting to new laws and risks. This concept reinforces the accountability principle, where organizations must not only comply but also demonstrate through artifacts that compliance is embedded in their operations. Workforce training ensures that employees understand their privacy responsibilities in line with their roles. Training may be general, covering awareness of privacy policies, or role-based, targeting specific functions such as HR, marketing, or IT. For exam candidates, the key idea is that training is both a requirement and an accountability mechanism. Organizations must be able to show regulators that staff have been educated appropriately. Training also supports culture, reinforcing privacy as part of daily practice rather than an abstract compliance goal. In practice, effective training reduces risk by preventing errors such as mishandling data subject requests or improperly disclosing information. On the exam, expect scenarios that test whether training obligations have been met or whether failures in training undermine an organization's compliance posture. Vendor risk management represents a life cycle of due diligence and oversight for third parties handling personal data. It begins with assessment during vendor selection, continues with contractual obligations such as data processing agreements, and requires ongoing monitoring through audits or certifications. Vendors often pose significant privacy risks because they sit outside the organization's direct control. For learners, the life cycle is the key term, emphasizing that risk management is not a one-time event, but continuous oversight. Exam scenarios may describe a vendor breach or contract failure and test whether the organization's risk management practices were adequate. In practice, strong vendor management reduces liability by ensuring accountability extends throughout the data ecosystem, reflecting the interconnected reality of modern business operations. Cloud computing introduces unique challenges for privacy governance. In cloud arrangements, the roles of controller and processor determine responsibilities. Controllers determine the purposes of processing, while processors act only on instructions. Understanding this allocation is crucial for both contracts and compliance. For example, a healthcare provider using a cloud service must ensure HIPAA business associate agreements are in place, clarifying each party's obligations. For exam candidates, controller-processor distinctions are critical, as they influence who bears legal responsibility in scenarios. Cloud computing also raises questions of jurisdiction, as data may reside in multiple locations. Recognizing how cloud models intersect with privacy law helps candidates apply both contractual and statutory requirements with precision. Data processing agreements, or DPAs, operationalize these controller-processor relationships. They establish obligations for service providers, including restrictions on data use, requirements for security, and conditions for subcontracting. Standardized clauses, such as standard contractual clauses for international transfers, provide recognized frameworks to meet legal obligations. For learners, DPAs represent a contractual safeguard that translates privacy principles into enforceable commitments. Exam questions may ask whether a scenario requires a DPA or whether its absence represents a compliance failure. In practice, DPAs are vital tools for demonstrating accountability, ensuring that organizations cannot outsource responsibility for privacy but must extend obligations contractually through their vendor networks. Incident response programs are essential for addressing modern threats, such as ransomware or vendor breaches. These programs outline detection, escalation, containment, notification, and remediation steps. For exam candidates, key terms include incident response and notification, emphasizing that organizations must have structured processes for reacting to security events that affect personal data. Scenarios may test whether an organization's response meets statutory timelines or whether vendor incidents trigger downstream obligations. In practice, effective response programs minimize harm and demonstrate accountability to regulators and consumers. They highlight that privacy compliance extends beyond prevention into resilience, ensuring that organizations can respond effectively when controls fail. Accountability models require organizations to prove compliance, not simply claim it. Demonstrable artifacts may include training logs, policy documents, assessment reports, or audit results. For learners, accountability reflects a shift in regulatory philosophy. Regulators no longer accept trust without verification. Exam scenarios may test whether described documentation constitutes adequate proof of compliance. This reinforces that privacy is not only about having controls, but also about being able to show they exist, operate, and are effective. For organizations, accountability models shape the design of programs, requiring careful documentation and continuous review to build evidence that compliance is more than rhetoric. Preference management, consent records, and withdrawal handling illustrate how organizations interact with consumer rights. Systems must track when and how consent was given, honor withdrawals promptly, and manage preferences across channels. For exam purposes, these terms emphasize transparency and control, demonstrating how consumer empowerment is operationalized. Scenarios may describe opt-out or withdrawal requests and test whether an organization responds adequately. In practice, preference management builds trust, ensuring that individuals feel in control of their data. It also serves as a compliance safeguard, as records of consent provide evidence in the face of regulatory scrutiny. This area illustrates the integration of legal obligation with consumer-facing practice. Records retention schedules and defensible deletion ensure that personal data is kept no longer than necessary, but preserved when legal or regulatory obligations require. Retention schedules define how long different data categories are stored, while defensible deletion ensures that once the retention period ends, data is destroyed securely. Legal holds suspend deletion when litigation or investigations are pending. For candidates, the key terms are schedules, deletion, and legal holds, reflecting the balance between compliance and risk management. Exam scenarios may ask whether an organization's retention practices align with statutory or contractual requirements. In practice, retention and deletion policies reduce risk exposure and demonstrate responsible stewardship of personal information across its life cycle. Online tracking, profiling, and behavioral advertising raise privacy concerns by monitoring user activity across websites and platforms. State laws increasingly regulate these practices, requiring notices, opt-outs, or explicit consent. For learners, key terms include profiling and behavioral advertising. emphasizing how data about online behavior can create sensitive insights about individuals. Exam scenarios may test whether described tracking requires disclosures or consumer rights mechanisms. This area highlights the evolving nature of privacy law, where technological practices challenge traditional consent models and push regulators to adapt quickly. Understanding these terms ensures candidates can navigate questions about digital advertising and its intersection with consumer rights. International transfers remain one of the most challenging areas of privacy law, shaped by decisions like Schrems I and II from the Court of Justice of the European Union. These cases invalidated frameworks such as Safe Harbor and Privacy Shield, forcing U.S. companies to rely on mechanisms like standard contractual clauses or, more recently, the EU-US Data Privacy Framework. For exam candidates, the key terms are transfers and mechanisms, highlighting how cross-border data flows require explicit legal safeguards. Scenarios may test whether a described transfer is compliant under recognized frameworks. In practice, this area underscores the interconnected nature of privacy, where U.S. professionals must understand international developments that directly affect domestic operations and compliance strategies. By mastering Domain Y, candidates connect structural legal concepts with operational management practices. This synthesis ensures not only the ability to answer exam questions accurately, but also the capacity to design, implement, and defend privacy programs in real-world contexts. Domain I provides the scaffolding for all subsequent domains, linking the architecture of law and enforcement to the practical tools of information governance. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.